Hello friends, welcome to AQBIS YouTube channel. This session is a part of our quick revision series PRELIMS ATULYA. In today's session, we'll discuss the significant aspects related to Indian judicial system. Actually, we are continuing our previous session. If you recall, we discussed some basic concepts related to judiciary in our previous session. We discussed about the Supreme Court, jurisdictions of the Supreme Court. We discussed why we need an independent judicial system. So in today's session, first let's talk about the appointment of judges. So let's try to know how judges are appointed. So as far as the Chief Justice of India is concerned, remember CJI is appointed by the President. Okay, and as per the convention that we have developed a convention, and in accordance with that convention, usually senior most judge is appointed as the Chief Justice of India. So remember, this is the tradition, this is the convention that we have. However, this convention was broken a couple of times, but usually this is the tradition that senior most judge of the Supreme Court is appointed as the Chief Justice of India. What about other judges? Remember, other judges are appointed by the President again, but in consultation with CJI. Okay, so what do we mean by consultation of the CJI? Remember that CJI recommends the names of the persons to be appointed, but in consultation with 4 senior most judges of the Supreme Court. Okay, so this system is known as Collegium system. Let me repeat one more time that CJI is recommending the name, but in consultation with other 4 senior most judges. And after that, those names are considered by the President and they are appointed as the judges of the Supreme Court. Okay, I hope you must have understood this topic, appointment of judges. Now let's talk about the judicial activism. See, PIL and judicial activism, these terms are often discussed whenever we talk about the judiciary. You know, you must have heard people say that this person has filed the petition, this person has filed the PIL, or Supreme Court has responded to a certain PIL. Okay, so PIL is the vehicle of judicial activism. Okay, so this concept of PIL, which is public interest litigation, it was introduced by P.N. Bhagwati. Okay, so let's try to know this concept. See, before 1979, if you are an aggrieved person, then you would go to the court. So if there is the violation of any right, in that case you would go to the court. But after 1979, this system underwent a significant paradigm change. So what happened, that now even the people, even groups on the behalf of aggrieved persons, they can go to the court, they can knock the doors of the court. Okay, so right now, even remember, groups can access the judicial system. So judicial system has become far more democratic now. So this PIL, it has had a positive impact on the judicial system. Okay, moreover, this PIL, it has forced the executive accountability. Okay, now executive, they are far more accountable because they know that judiciary might ask them to bring about some reforms. So they are far more accountable now. Okay, in fact judiciary has brought about the reforms in the electoral system, because electoral system is far more fairer, far more impartial now. Okay, so candidates who are contesting the elections, they are supposed to submit their details regarding educational qualifications. They need to provide the details regarding their assets. So all these things are happening only because of the judicial activism. Let me repeat one more time what we have just studied. PIL, under this PIL concept, even groups, even people on the behalf of aggrieved person, they can approach the court. So under this PIL concept, judiciary is seeing the larger interest of the society. So things have gone beyond the individuality. Now judiciary is looking at the larger interest of the society. So this is the concept behind PIL. Now this PIL concept, it has had some negative impact also. How? Because court is far more overburdened now because of these PILs. And remember that there is this separation of power. So separation of power, legislature plus executive at one place and judiciary at another place. So this separation of power, it is getting violated now because of the PIL. Some people believe that. How? See, electoral reforms which were introduced by the judiciary, executive could have done that. Executive could have enacted a legislation which would have brought about those reforms. So now judiciary is doing what executive could have done. So because of the judicial activism, this thin line of separation of power between executive and judiciary, it is getting blurred. So this thin line is very delicate and it is getting violated because of these PILs. So this is the negative impact it has had. Okay, now let's talk about our rights, our fundamental rights. So we discussed in our session of fundamental rights that in the case of the violation of fundamental rights, you can approach the Supreme Court. Either you can approach the Supreme Court or you can approach the High Court. So we have Article 32. So under Article 32, you can approach the Supreme Court, and under Article 226, you can approach the High Courts in the case of the violation of fundamental rights. After that, Supreme Court will issue the writs, Supreme Courts or High Courts. And we discussed that writs are special directives for the enforcement of your fundamental rights. So just remember Article 32 and Article 226. Okay, so writs will be issued in order to restore your fundamental rights. Now, let's talk about the judicial review. See, judicial review means that suppose the legislature has enacted a law. A law has been enacted, and this law, it is against the provisions of the Constitution. Then what Supreme Court can do? Supreme Court can declare this legislation null and void under Article 13. So under Article 13, Supreme Court has the power of judicial review. So it can examine any legislation. So it can examine any legislation, any law under this power of judicial review. So remember Article 13. And there is one more important point. Do not forget that this concept of judicial review, it is mentioned nowhere in the Constitution. Let me repeat one more time that Supreme Court, it has the power of judicial review. And under this power, judiciary, Supreme Court can examine any law or any legislation to check the constitutional validity of that law, whether that law is in line with the constitutional provisions or not. In case that law is against the provisions of the Constitution, then Supreme Court can declare that law null and void. Okay, and remember this concept of judicial review. This is very, very important, and there might be a potential question on this topic. This judicial review concept, it is mentioned nowhere in the Indian Constitution. So all these facts are very, very important and can be asked in your upcoming prelims. And I have provided some topics which have been in the news in the recent times, like Lok Adalats. Okay, these Lok Adalats are established under Legal Services Authorities Act 1987. So this topic, it has been in the news in the recent times. So you can go through this slide in order to know about this topic. and National Legal Services Authority. It has been in the news also. So remember that Chief Justice of India is the patron in chief of this National Legal Services Authority. And the second senior most judge of the Supreme Court is the executive chairman of this National Legal Services Authority. Okay, and you can download these notes and you can start revising. Your prelims is around the corner, and all these facts are very, very important. So all these points I wanted to discuss in today's session. If you have liked our initiative, you can subscribe our YouTube channel for more such videos. You can follow our social media platforms for daily current affairs content, and if you have any suggestions, you can mention in the comment section. So that's all for today's session. I'll see you in the next session soon. Bye bye.